this is where, for me, this conversation's been so valuable. You're not saying all what I would call uncharged conduct is off the table. It's all conduct that's kind of separate. And of course, here's another point, which is itself useful. Maybe the answer here is not to advise the commission to rework its acquitted conduct rules. Maybe the answer here is to advise the commission to rework its relevant conduct rules.
This whole preponderance of the evidence crap and the cornerstone behind the guidelines, the commission always promised they would take a hard look and look at those two cornerstones of the guidelines, and they never have. And that's really what they should do. Forget about all this acquitted conduct stuff, because they can't do anything about it anyway, according to Alito, and I think he's right. But they can do something about relevant conduct and 6A 1.3 about this preponderance of the evidence. It's time that they take a look at that. And some of these sentencing factors, like loss and drug amount, should be have a higher evidentiary standard at the very least.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, it's Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Listen, in a perfect world, don't we know that the presumption of innocence is sacrosanct? But in federal court, even if a jury finds you not guilty, the conduct underlying that acquittal can still be used to enhance your sentencing in a later case. What is up with that? Not only that, the court can enhance your sentence for things you were never even charged with. So I did a podcast with the two fine gentlemen and scholars I'm about to introduce several months ago. It was episode 36. And it was all about acquitted and uncharged conduct under the guidelines in federal court. And now it's time for a follow-up. There have been, I guess you can call them, some developments that are certainly worth discussing. So therefore, helping us get set for sentencing today, Professor Doug Berman and Mark Allenbaugh. How you doing, gentlemen?
Just great.
You're ready to rumble. You're ready to rumble. Okay, so yeah, I'm going to do my best Troy McClure voice. You might remember Professor Berman. No, he not only a federal sentencing expert and a law professor at the Moritz College of Law at the Ohio State University, but he authors the incredible, phenomenal sentencing blog, and particularly relevant to this discussion, he wrote the amicus brief for one of the acquitted conduct cases that was lingering up there at the Supreme Court, U.S. versus Daytona McClinton. And that's a case we hope the court would address. And then, of course, we all know our returning champion, Mark Allenbaugh of sentencingstats.com fame, guidelines guru, good friend as well. Mark actually just authored an article on this for Law 360 along with Alan Ellis. It's called "The Supreme Court Must End Acquitted Conduct Sentencing." And I'm going to put a link to the show notes, to that article in the show notes, so you guys can read that if you like. But that's what we're going to be talking about right now. We did do a deep dive on this, so we're going to try not to rehash so much old ground. But in 30 seconds or less, what is acquitted conduct and who cares? I'll either one of you or both of you, maybe you have different perspectives.
Well, acquitted conduct is exactly what it sounds like. You've gone to trial and you have been found not guilty by a jury or sometimes a judge. And so the issue with respect to acquitted conduct sentencing is that conduct that you were acquitted of, that a jury found that there was not sufficient evidence beyond a reasonable doubt to find you guilty. Can you still be sentenced for that? And then frankly, the issue is, what role does the presumption of innocence play in that regard? Okay. That's the way I would frame it.
I like that framing. Do you have any different take on that, Professor Berman?
I'll add, especially assuming that we're going to get to some division that Mark and I have about whether acquitted conduct
Oh, yes.
is in the same position as what's sometimes called uncharged conduct or other conduct used to enhance sentences that isn't acquitted. What I think particularly distinguishes acquitted conduct and is worth kind of highlighting at this opening stage is to become acquitted conduct, it first needs to be indicted conduct. It needs to be in an indictment that's going to go to a defendant, and the defendant is going to be either, assigned or hire a defense attorney. And that defense attorney is going to say, among other things, they wouldn't have brought an indictment against you unless they thought they had a pretty good charge against you. You're really at risk of possibly being convicted of that. Let me tell you a couple things about this story. One is, if you go to trial and are convicted, you're not going to get a credit for acceptance of responsibility. Your statutory range is going to be higher on that charge in addition to whatever other charges are in this indictment. And some defendants, most defendants, are going to end up pleading guilty. Not necessarily to that charge, that in some other worlds could be an acquitted charge, but I think it's so important right at the outset to highlight that an acquitted charge doesn't lead to acquitted conduct unless there's that initial charge, and prosecutors get all these benefits from bringing that charge in the first instance that serves, maybe in a good way, maybe in a bad way, to distinguish it from other kinds of uncharged or other sorts of conduct that might come up at sentencing. And then, of course, most fundamentally, you don't get an acquitted count, you don't get acquitted conduct unless a unanimous jury at trial rejects that charge, right? It could be a hung jury. Elizabeth Holmes, we might want to talk about her later, is an example of somebody who had hung jury conduct, but an acquitted charge is the product of 12 citizens picked for jury duty collectively saying, the government's allegations here, we don't think should lead to a conviction on this conduct. And then the government says, well, that was nice. Isn't it nice the jury decided to reject my allegation? Who cares, judge? They have a standard of beyond a reasonable doubt. You, judge, have a lesser standard. And among the things I hope we'll talk about is it's actually never been constitutionally established what that standard is that a judge has to use to consider any kind of conduct or other factors at sentencing. But the key point is the government emphasizes there seems to be plenty of Supreme Court law to support the idea that a judge not only can, but is perhaps duty bound to say, yeah, you jurors, that's cute that you thought this charge wasn't established beyond a reasonable doubt. But for me, it's close enough for government work. And as a result, I'm increasing your sentence on the basis of that conduct for which a unanimous jury said you should not be convicted.
Okay. So, when we talked a lot about this the last time, it was substantive. It was all about acquitted conduct and a lot of the issues you bring up, Professor. But before we get to that, I think what motivated, and that is going to be a big part, a thread running through this discussion, is how far does it go, acquitted conduct to uncharged conduct to relevant conduct. But let's put a pin in that for a second, because putting the substance aside, I think one of the things that motivated the three of us to get the band back together was the procedural aspect of this. And I was trying to come up with a pithy name for this, and I'm a big fan of Schitt's Creek, that show, and there's a great scene in there where David and Alexis are arguing over which bed they should get in the hotel room and which one is closer to the door, and the one that's closer to the door is the one that gets murdered first, and they go back and forth. No, you get murdered first. No, you get murdered first. And I feel like that might be the episode, the title, because this has been since the last time we got together, it's just been ping pong back of, the Supreme Court's going to do this. They're going to take this up. They're going to decide this. And, the Sentencing Commission was saying, let's let the Supremes decide. So Tell me about the ping pong game and what is going on with that?
Well, the Sentencing Commission, every year it has a period of time where it considers proposed amendments to the guidelines. And first thing it does, it'll take up issues for comment. Now, what should we as the Sentencing Commission consider for this amendment cycle? Then they consider all these things, and they'll promulgate, or they'll propose amendments. They'll go through a notice and comment period, and then they will publish actual, or they'll promulgate actual amendments to those guidelines. Those end up going to Congress. If Congress does nothing after 6 months, then they become law, if you will, but they become part of the sentencing guidelines. And so what happened here, there hasn't actually been a commission or a functioning commission for several years. Finally, we got a full batch of 7 commissioners last year. And one of their issues for comment that they wanted to address was acquitted conduct. And whether acquitted conduct should be considered when a judge calculates the sentencing guidelines. So they published that in a notice period. Should we consider this? Is this an issue we should take up? And they overwhelmingly heard from the public that yes, take this up. And so they did. And they actually went through and they published an amendment to the guidelines, a proposed amendment. This wasn't their final amendment, but a proposed amendment that would have reduced or limited the use of acquitted conduct at sentencing. Basically, what this proposed amendment said was that you, sentencing judge, could not use acquitted conduct to calculate the guidelines. In other words, you couldn't use acquitted conduct to enhance offense levels. So Elizabeth Holmes, well, that's probably not a good example because she wasn't acquitted of some of those conduct. But if a defendant was convicted of one fraud for $1 million and acquitted of another fraud for $1 million, that $1 million that the defendant was acquitted of couldn't come back in and be used to enhance the guideline range, which it is now. That's the way it is now. But there were some exceptions, some troubling exceptions to that, though, that the commission had proposed. And one was that within the guideline range, a court can still consider acquitted conduct within that guideline range to determine where the actual sentence could be. Not a big deal if you're talking low level, if the offense levels are rather low. A very big deal once you start getting up to higher offense levels, because that guideline range, as the offense levels go up, the range, the sentencing range, can increase quite a bit. And the other thing that was very troubling, and it was basically an exception, in my opinion, an exception that assumed the rule, was that courts could still use acquitted conduct for purposes of an upward departure. And as we know, the guidelines are merely advisory. So basically what that said was, basically the commission was giving with one hand and taking away with the other. Yes, you can't use it to calculate the guidelines, but you can use it to calculate the final sentence. So it was kind of like a magic trick, or a 3-card Monty, if you will. Okay. And the commission got a lot of negative feedback from that from the public, but nonetheless, it was still hopeful that after all these years, after all the debate about acquitted conduct, that it would finally at least take a small step in the direction to get rid of acquitted conduct, at least for purposes of calculating guidelines. And surprise, surprise to everybody, it decided to punt and say, we noticed that the U.S. Supreme Court has a bunch of these petitions for cert pending right now. So we're going to let the Supreme Court handle it before we take a look at it. Okay. And as it turned, okay. Do you want me to go on?
Yeah. So we'll kick it to Professor to talk about what happens in the court. But I will say this is how we geek out on this stuff, because for the last almost year, I'm getting emails bouncing back and forth between these two men. Like, this is the time the Supreme Court's going to take it. It's going to happen. It's going to be on the calendar. Really. Oh yeah, that was all you, and it just never happened. So what happened, Doug Berman, Professor?
I'll provide a little more backstory that especially I think contributed to this being a robust moment to get excited about the possibility of the court getting involved. As folks may recall, this goes way back, but now almost more than 20 years ago, we had what might be called kind of the Sixth Amendment revolution in the application of sentencing guidelines, where the Supreme Court in a series of cases, Apprendi, Blakely, Booker, said, as a formal legal matter, if fact-finding increases the sentencing range that a defendant is legally eligible for as a matter of formal law, that can no longer be found just by a judge. That's essentially an element that has to be treated with the jury trial right and proof beyond a reasonable doubt. And that, among other things, the remedy at the federal level is to make the guidelines advisory. So we now only have the statutory ranges, not the guideline ranges, defining precise legal authority there. However, they still have the guidelines mattering a lot, and how fact-finding within the guidelines could still be subject to constitutional limitation or debate is part of where kind of all of this contributed to uncertainty, and an uncertainty that many defendants brought to the court for quite some time, but where I perceive that Justice Breyer, who, though a somewhat pro-defendant justice, but not a big fan of the Sixth Amendment jurisprudence, pushed back, and I think got his more liberal colleagues to not be open to considering this acquitted conduct issue while he was still on the court. Perhaps not surprisingly, the first term he's not on the court, a whole bunch of folks say, in fact, reached out to me to encourage me to do what I think was now like the sixth variation of my amicus brief on these issues. And I sort of said, I don't know, it doesn't seem like the court has much of an appetite for this. And they said, not wrongly, with Justice Breyer gone and now former sentencing commissioner Justice Jackson in his seat, maybe there's more excitement, energy for these sets of issues. And so that not only led to a whole bunch of folks filing a whole bunch of amicus briefs on a whole bunch of new acquitted conduct cases to bring to the court, we saw a pattern of the court continuing to relist the case. And that's sort of a signal among Supreme Court nerds, oh, the court's interested in this topic, right? If they, in a number of earlier terms, I did amicus briefs, other people presented the court with acquitted conduct issues, and they denied cert right away without really much consideration. There was one famous dissent 10 years ago, but since then it seemed like there was no action at all here. But now it seemed like, this is why you were getting all those emails, Doug. Mark and I thought, okay, we've got a lot of energy, we got a lot of interest, and we've got a lot of new justices. And I want to emphasize this point. It wasn't just the new Justice Jackson replacing Justice Breyer.
Right.
It was also the Trump judges, Gorsuch, Kavanaugh, Barrett, all of whom in various incarnations earlier in their careers had at least hinted that they may be troubled by this too. And importantly, and I think an important missing piece of this conversation going forward, Justice Thomas had previously dissented on the court's failure to take this issue up 10 years ago. So there were those of us kind of head counting here that were thinking, boy, maybe there's 7 or 8 justices who now want to take this issue on. And boy, here are a bunch of good vehicles. Oh, goody, they keep relisting this. That means they're just gearing up to take it. It's only a matter of time. And then, of course, we ended up getting, just to square the circle, on the very last day of this current term, or this past term, a bunch of statements and then a dissent in response to these petitions, basically saying, we kind of think this is important, but nope, sorry.
I want to go back, if I can interrupt just one second. I want to go back before we leave to Breyer. I think you raised an interesting point. And just to remind all the listeners out there that Breyer actually was one of the first commissioners. He along with former Judge Willie Wilkins started the commission, and I think he was a commissioner when he was still on the First Circuit, and then he was elevated to the Supreme Court. But in that regard, I'm just wondering how much Breyer, because the court wouldn't take up acquitted conduct sentencing, I'm just wondering, and maybe this is a conspiracy theorist, that he saw if the court took up acquitted conduct and held that it was unconstitutional, what might happen to the commission as a whole, or to the guidelines, I should say, maybe not the commission, but to the guidelines, that it would be even more revolutionary than Booker. And that's, I think ultimately where our brawl is going is uncharged conduct and whatnot. But I'm just curious, Doug, what you think about that. Was it Breyer just really pushing back on taking this issue while he was on the court because he saw down the road what would happen, what could happen to the guidelines in terms of if the Supreme Court ruled that acquitted conduct was unconstitutional, and that my argument is, well, if acquitted conduct is unconstitutional, then so is uncharged conduct, and that underlies all relevant conduct, that's going to blow up the guidelines. And he kind of saw that coming.
I certainly think, and we see this going all the way back to the Apprendi and Blakely and Booker line of cases, right? Every justice who is comfortable with a world in which judges do a lot of fact finding in support of sentences is comfortable with a world in which Fifth and Sixth Amendment rights don't attach to that fact finding, right? And so any ruling or decision that troubles them against that backdrop is going to lead to disaffinity for taking the case up. And we can look even back to the Hayman case, which has to do with fact finding for supervised release revocation and imposing prison terms. And there were 4 votes for applying a jury trial right to that kind of fact finding by judges to put people in prison, 4 votes against it. And then Justice Breyer says, well, I don't believe in fact finding for this kind of stuff, but this was a unique setting where there was a 5-year mandatory minimum, and that feels more like what trials are. So I'll be the in-between guy here, but not the in-between guy who's going to bless that old jurisprudence, which is of course established jurisprudence, that the Fifth and Sixth Amendment put some limits on judicial fact finding in these kinds of sentencing settings. So I certainly think Breyer saw the risks there, though again, I don't think it's risks that are, oh, I think acquitted conduct sentencing is bad, but I don't want to go down that route. I think he just doesn't think it's bad. He thinks that judges should have full authority to find whatever they want and think is best, because he was always kind of a judge guy. That's why the guidelines get built the way they do.
And that's why
think,
I'm sorry, just one quick point.
Go ahead.
But that's why Breyer, I think, wrote the remedy opinion in Booker and saved the guidelines. Because remember, Booker, I still believe, is like a unique opinion where you have 2 majority opinions, because Ginsburg joined both dissents, if you will. And Breyer was the one that wrote the portion of the second majority opinion that said that the guidelines here are going to be merely advisory, and nobody had briefed that and all this other stuff. So I think he was the laboring oar in trying to save the guidelines. So
so I'll be quick to say save his version of the guidelines.
Yes,
which
save his version.
I think you think as well is a terrible version of the guidelines.
Yes,
and
thank you.
Among the
touchdown USC.
Among the many reasons why saving the guidelines was important to Breyer, but I think a terrible thing is it creates a world in which we can get these intricate fact-finding regimes that don't have any real connection to culpability, don't have any real connection to the kind of things that we think a criminal justice system really should be focused on. But because we're administering it through a bureaucrat known as a sentencing judge, we kind of, all right, that's how government's supposed to work in Justice Breyer's mind, not in the mind of what I think a sensible sentencing system should be doing.
Right.
I do see this as potential seismic shift, like Blakely, like Booker, and the Supreme Court freaking out. And you mentioned this last time, Mark, that even the government said in some of their briefing that if you kill acquitted conduct, the dominoes will fall and unravel, uncharged and everything else. So what they're doing now is saying, you get murdered first. They're punting back to the commission. They've said in their denial that no, the commission's gonna do this. They're gonna do this. But the truth is, with all that history, Mark, that you put forth, they took it off the table. And where are we with the commission? Are they gonna do something now?
So that's kind of just fill in that gap for your listeners real quick. So on the last day of its term, there were at least 13 petitions pending on the issue of acquitted conduct, including the McClinton case that Professor Berman wrote an amicus in. And some of those petitions have been pending for over a year. So it was quite surprising that they just denied all of them. And we'll get to some of the statements that were made in those denials. But the primary reason why they denied it, and the primary statement regarding the denial of cert was made by Justice Sotomayor. And she said, well, the commission is considering this stuff, so let's wait. And then Kavanaugh, joined by Gorsuch and Barrett, said the same thing. Yeah, we agree with Sotomayor. let's wait and see what the commission does. But the commission was already on record saying, well, let's wait to see what the Supreme Court's going to do before we act on this. So we need more time to consider this. So,
Yes.
so now we're in a purgatory because the commission, right before, right before the, or not right before, but shortly before the Supreme Court had denied cert in all these cases, the commission had published its proposed priorities for this coming amendment cycle. Nothing in there about acquitted conduct. Zip. Now,
Yeah.
that doesn't mean that the commission can't, this was just a publication for proposed priorities. They have not published their actual priorities yet, and they're going to take the summer to consider all the statements from the public, and hopefully a lot of us are going to write to the commission and say, you need to take up acquitted conduct.
Yes.
But one of the things, though, Alito said in his statement regarding, in support of the denial of cert for McClinton and all the other cases, was that even if the commission takes this up, even if the commission takes up acquitted conduct sentencing, that has nothing to do with the constitutional issue, and it has nothing to do with all the states out there. There are many states that still have acquitted conduct sentencing, and nothing the commission does, which is strictly federal, is going to affect any of the states. So waiting on the commission is, at least to Alito's mind and mine too, is a non-starter, because the commission is going to be very limited in what it can do. But right now, the commission has not officially published any notice that it is going to add acquitted conduct sentencing.
Yeah.
So what Sotomayor, the way that she left it, is if the commission doesn't act quick, then we may have to take it up again. And my response to Sotomayor is, no, yeah, you have to take it up. And that's why I wrote that article.
Right.
The commission isn't going to do anything.
Right. So okay. So we have a couple of action items that have come up then. First of all is reach out to the commission, let them know, let's take this up, let's deal with this. And also for you lawyers, or keep raising this issue. This issue is still alive, very much alive. Keep raising it in your cases. And keep raising it, not just for acquitted conduct, because that's relatively rare when it comes up that a person's gone to trial and been acquitted, but raise it for relevant conduct, raise it for uncharged conduct, which I think is a perfect segue into the main. Now I'm going to give you my and this is the big debate between Mark Allenbaugh and Professor Doug Berman about whether we're just talking about the relatively rare instance of acquitted conduct or whether the dominoes may fall, because uncharged conduct, relevant conduct, these other things that a person may have done, allegedly done bad in their past, but never been charged for or convicted of, come up over and over and over and over again. And that is a real big problem. Mark and I have just had a case like this, with conduct that was never charged going back 10 years, right? And the client got a significantly longer sentence as a result of the things that they think he was up to, not the things they could ever prove that he was up to. So I'm going to give you my editorial, and maybe this is going to frame the debate or kick off the debate. But this, to me, acquitted conduct, uncharged conduct, all of it is a symptom of a larger sickness in our system, which is that the jury trial in general has become essentially irrelevant. It's gone the way of the dodo. Mark, you pointed out in our last podcast together something in federal court like 98.3% of every person who's charged in federal court, they're not getting a jury trial. They're pleading guilty. That is the way our system works. Nobody goes to trial anymore. And that's because of coercive plea bargaining. It's because of draconian sentencing statutes. It's because of the downright terror that our clients feel when they're wrapped up in this meat grinder of a system that we call the criminal justice system. Trials almost never happen, which means we've lost all respect for the constitutional cornerstone that made our system ostensibly great. So it stands to reason, I think, that we'd extend that disrespect for juries and proof beyond a reasonable doubt into sentencing and just say, we don't need to prove any of this stuff. We don't need a jury trial. We're just going to hammer you for this stuff that we think you might have done. And it's open season on you. It's
Mhm.
sentencing. And that's the way it's been since basically the guidelines were created in the 80s. We hoped there'd be a favorable resolution to the matter. There hasn't yet been, but let's just talk about it. Doug Berman, why don't Mark? We know what you think. And by the way, I'm with you. But Doug Berman, why do you think that the line stops, the buck stops at acquitted conduct and relevant uncharged conduct wouldn't fall to if acquitted conduct fell?
Well, again, and now I'm going to be law professory, and the question is,
Okay.
what are we talking about, right? Are we talking about the jury trial right? You just gave a effective and impassioned statement about the importance of resuscitating our jury trial rights. That's a Sixth Amendment right. It's also arguably an Article 3 concern as well, because the jury trial is the only procedure that finds mention both in the body of the Constitution and in the Bill of Rights. So there's no doubt that from an originalist perspective, and there's much talk about an originalist.
And sorry to interrupt, as you raised in one of your blog, the Declaration of Independence as well.
That is true as well. So if we are true originalists, we should rightly concern ourselves a lot with jury trial determinations, distinct from other kinds of determinations. So if we're going to drill into the importance of that, then the consequences of an acquittal ought to be more profound than the consequences of not having a trial at all, though we can talk about how this all comes together functionally, and I want to get back to this point. But there may also be, more accurately, I share the sense that the Fifth Amendment due process clause also places limits on what judges should be able to do at sentencing. Here's an important point. Everybody actually agrees with that proposition. There can be big debate over how much the jury trial right should influence sentencing, but there's nobody that I've ever talked to who says, oh, if the judge shows up and has a belief that the defendant's lawyer parked in his special parking spot, then he should be able to max out the defendant in that case, right? And what would that violate? I think we would think that would violate due process, right? Because he may have authority to max out the defendant on other facts and factors, but we would think it's outrageous that just because the judge is grumpy and perhaps wrongly thinks that the defendant's lawyer parked in his space, that's a reason to max a defendant out. I bring that up because I'm very supportive of the idea, especially because every one of our interpretations of due process is quite nuanced, that we ought to bulk up our standards of proof and our obligations for what due process demands of judges before judges can increase sentences. But to me, that is a very distinct concern than acquitted conduct, where we've gotten the jury trial right invoked and involved. Now, add extra law professory goofiness to it. I do think there are settings in which a defendant should have a right, because the consequences are so great, to demand a jury involved, as well as to demand proof beyond reasonable doubt. I'd be tempted, again, being law professory and using existing doctrine, 6 months is generally what we think is the severity of an available punishment that can potentially trigger a jury trial right under petty crime jurisprudence originally, on and on and on. I don't want to give you all the particulars. I want to emphasize the point that I think it's beyond dispute that if the Sixth Amendment is of any importance at all, there has to be some kinds of distinctions between acquitted conduct and all other conduct. What we want the rules to be for all conduct is an important debate, but it is a different debate than a debate that is concerned with respecting our jury trial rights and everything that should go with it. So I think I start from the proposition acquitted conduct has to be different. Maybe we want the standards for uncharged conduct to be so severe that it gets wrapped up into that. But I still think it's different.
Okay,
Well,
before you retort, Mark, I just want to clarify. Did I hear correctly that you're making a case for getting a jury for sentencing? Is that what you're saying?
I am definitely saying if you think the jury trial right, as I do, is really important, then that right carries to more than just a guilt determination, right?
Okay.
And I can give you lots of good examples. Capital punishment. We have juries that make recommendations, and we think that's generally a good idea. Very few states have moved off of that. And there's lots of reasons we could talk about that. I would like a world in which we said the Sixth Amendment demands that before you get punished with life without the possibility of parole, essentially a functional death sentence, the same sort of solicitude, the same sort of jury advice, not always determination, but advice ought to be fundamental, because the voice of the people should be
Okay.
represented before state power is used that way.
I think
Whether we might apply that to mandatory minimums, I'd be inclined to do so. Whether we might apply that to every sentence over a decade or 2 decades, again, I'm eager to go there. But to me, this is where acquitted conduct is different in kind, because it's jury impacted determinations that ought to get extra respect if we care about jury trial rights.
Okay.
Well,
Mark.
okay, so I like the idea about jury sentencing, but I'm going to vote no.
Okay.
For the reason why Virginia has done away with jury sentencing is, jurors often are way more punitive than judges. So just on that issue, I mean, I think that's kind of a tangential issue. But
it's not. Wait, let me jump in. We're gonna
wait,
fight.
you never
It's
let
not
me jump in.
Let me finish my thought. That cannot be a tangential issue, because it's fundamentally, if your principles are, Mark, if your principles are, I don't want sentencing to be too severe. That's a very different.
No.
I want sentences to represent the voice of the people.
Well, yeah, but yeah, I don't think sentencing. I think you can have sentencing representing the voice of the people through a judge, through guidelines and things of that nature. Just having jury sentencing across the board. What you're asking for is throughout the guidelines, and we know the whole reason why we have guidelines.
I'm not saying that either. Juries can and do apply guidelines all the time. It's called our historic homicide approach.
Well,
right?
not guidelines the way we're talking about sentencing guidelines. We don't.
Well, that's a problem with guidelines, not a problem with juries.
Okay. And by the way,
let me get.
I want to. Okay, I'm going to get you, but I want to interject here because I think it's an important point about juries, the voice of the people.
Yeah.
Not only do we not have that in almost every instance, but you're not even allowed to bring up at a trial, Professor Berman, what the possible punishment may be. You're not allowed to let the jury know in a routine criminal case if there's a mandatory minimum and things like that. And I have done trials where the jurors have inadvertently checked a box that invokes a mandatory minimum, and they've been devastated afterwards. They said, I figured this was going to be a minor sentence. What? He's got 5 years? Oh my God. And so at the very least, I would advocate that jurors, because nullification is a thing, should be at least aware of the consequences of their guilty plea, but they're not. That said, Mark, let's go back to this. So Doug Berman, just to put it, he's saying when you have the imprimatur, the stamp of a jury trial saying not guilty or hung, that's somehow more significant than when you don't. And that's, I think, Professor, that's at the heart of your argument if we're going to give respect to the Sixth Amendment. Right. So let's focus, address that.
Well, presumption of innocence. This is, I think, the heart of the matter. And I'm going to point to Nelson versus Colorado, where Justice Ginsburg, this was a case a few years ago where it involved 2 individuals that had been convicted of crimes, and they were ordered to pay restitution as a result. They went up on appeal on their convictions. Their convictions were overturned, which is considered an acquittal. And the state of Colorado said, okay, fine, you were acquitted, but we're going to keep the restitution amount that you were required to pay as part of your penalty. Went up to the Supremes. Justice Ginsburg wrote this: axiomatic and elementary that the presumption of innocence lies at the foundation of our criminal law. Colorado may not retain funds, the restitution taken from Nelson and Madden, the 2 petitioners in the case, solely because of their now invalidated convictions. For Colorado may not presume a person adjudged guilty of no crime, nonetheless guilty enough for monetary exactions. Presumption of innocence, the way I read that is the presumption of innocence does not admit of degrees. You're innocent or you're not. It's a binary proposition. Binary proposition. So if that is the case, then there cannot be, as the government itself has recognized, a logical distinction between acquitted conduct and dismissed or uncharged conduct. You're presumed innocent of all conduct. It doesn't matter if it's been charged or not. There's no principle. There's no principle of law that says that. As a matter of fact, as a matter of okay. As a matter of fact, wait, let me finish. As a matter of fact, I think you have a less protection than with uncharged conduct than you do with acquitted conduct, because acquitted conduct, yes, it has been tested. You have some grand jury has said there is probable cause that you've committed this. That's how you get the indictment. But then another jury, the petit jury, has said, well, there's not beyond a reasonable doubt here. Fine. But with uncharged conduct, it's completely untested. You're still presumed innocent of that conduct. It doesn't matter. There's no principle in the law that I'm aware of that's ever been cited. And as a matter of fact, as I note in the Beck case a few years ago, the Michigan Supreme Court, looking at federal law, held that acquitted conduct sentencing was unconstitutional. But they, for whatever reason, decided, well, I know the reason. They decided to give a little short shrift, and they said that there's a difference between acquitted conduct and uncharged conduct, but they didn't cite any authority for that, and they just made a very brief statement about that. But even the government in the McClinton case conceded that there is no distinction. Alito himself said that there's no distinction between acquitted conduct and uncharged conduct.
I got two things to jump in on. The reason Alito says that,
it doesn't matter the reason. He recognizes.
No, it does matter the reason, Mark. The reason Alito says that, the reason the government says that, is because they know any sound thinking person recognizes that unless you want a system of fixed sentences where judges have zero discretion, so that every crime carries with it a fixed mandatory term.
But neither of them said that.
Wait,
I understand they don't say that. That's why you're getting tricked, Mark. You're getting tricked by, again, look who your friends are.
Wait a minute.
Friends on your position, your friends on your position are prosecutors and Justice Alito. That's because they understand that a world without any distinction between acquitted conduct and all uncharged conduct is a nonsensical world. So they're saying they want a nonsensical world. Let me ask you this question. Does the lack of family circumstances, is that a factor that the prosecution should have to prove? I assume you want beyond a reasonable doubt that the defendant doesn't support a defendant.
Are you asking me, should mitigating factors have to be proved to a jury beyond a reasonable doubt?
Isn't the lack of mitigating
that's never been the case.
Isn't the lack of mitigating factors an uncharged conduct?
Not necessarily.
So how do I figure out what it is?
No, it's not. No, it's not. It's absolutely not. For the exact reason that the government says in its brief, what it writes in McClinton in its brief in opposition is that an individual is equally presumed innocent when he is never charged with a crime in the first place. The logical implication of the Beck majority's reasoning would therefore preclude a sentencing court from relying on any conduct, and this is the important part now, not directly underlying the elements of the offense on which the defendant is being sentenced. So if something is relevant to that element of the offense, if it's underlying that element of the offense.
No, see, they say not directly. That's their point. Their point is
not directly. So if it is directly underlying,
so here's the question. A defendant's convicted of a drug offense. All right. Let's say
I'm sorry. I know
I want to hear this because I'm still not understanding how we get to fixed sentences and mitigation in this argument.
Yeah, neither do I.
But keep going.
Why I want to explain it to you. Let's use.
And by the way, this is the smackdown. I promise. This is a dream fulfilled.
Let's use.
But go.
Where's presumption
Professor?
Of innocence?
No, go ahead.
I want
Mark Allenbaugh, you are silenced now. I'm going to mute you.
Let's make it very simple. Let's use a classic drug deal that goes on in the defendant's house. Let's say the drug deal takes place in the basement, right? The drug deal involves only a certain quantity of drugs, let's say 0.5 kilogram of cocaine, right? Then the investigation is done. There was a confidential informant in there. They search the house. They find in the bedroom a gun, a lot more drugs, and a bill that says you're overdue on child support. Okay? Now we're sentencing the defendant for the drug offense.
Okay.
Can the judge consider that there was a gun in the bedroom?
Was it directly underlying one of the elements of the offense?
No, it's just a
What was
drug
he
charge. He
convicted?
pled guilty.
Okay, he pled guilty, and this is uncharged conduct, the gun?
Yes.
Yeah, no, not my, charge it. And we have statutes for that. Charge that. Any
Possession in
element.
relation to a drug trafficking offense. Yeah, it's
Yeah.
924C. If you
Okay,
can't
is that-
charge it and you can't prove there's a nexus
Wait, but
between that gun
in
and
the
the
state,
crime,
I didn't
then
say
no.
whether we were in state and federal system. There are state systems
Okay.
that don't have 924C.
Well, now
Yeah.
you're changing the goalposts.
Well,
I'm not changing the goalpost. You're positing that uncharged conduct is like acquitted conduct. What it sounds like you're really talking about is conduct that could be charged but isn't. That's
I'm
different.
talking about that also. I'm talking, yes.
Okay, you're talking
Yeah.
about that also.
wait, and I
Fine.
thought we were talking about uncharged, unpaid
Okay, but
child
let's go to the
support.
next
What's
one.
the child
The
support?
Yeah, but unchecked.
The additional drugs-
That would not be able to be considered.
The
Charge it.
additional drugs that are up in the bedroom.
The additional drugs, well, that's a sentencing factor. And that would presumably, in your hypothetical, and I will give
No,
you this, in your hypothetical, if there's additional drugs and that's part of this, it underlies the offense of conviction, then that can be used. That can be considered.
Where's the
that
presumption of innocence, my friend?
Well,
wasn't
That's what I'm
charged.
saying,
Yeah.
but no. He gave up the presumption of innocence when he was convicted.
but
That's what
I'm
saying.
no, well, Mark, how
Yeah.
do we, I don't know that, because why, if they had the evidence to show that those drugs and that gun was his too, why isn't he charged? Why doesn't he plead to that? It seems to me this is one of those classic situations where, God, we found this other stuff and we can't really say for sure whose it is, but we're going to fuck you with it at sentencing
Well,
either
yeah, but
way.
this is-
But I'll go further, Doug. They can say for sure whose it is. They're just cutting him a deal by letting him plead only to the stuff in the basement, right? So
Well, how's it a deal?
If that's the
How's it a
intent-
deal if he's going to get hit with it at
Exactly. So
sentencing?
If that's the, but see, that's
it's
the deal.
it's
If
a
that's the
deal. It's a deal because the government doesn't want to bring in the other drugs, where the defendant then will ask for a jury trial and create more costs and headaches for the judge, for the
But if he's still
prosecution.
going to get hammered with extra years,
Right,
for those
exactly.
drugs,
Well, depends.
then it's
It
then what you're doing is an
depends.
end run around proof and an end
Well,
run
but
around
again,
a jury
Mark was
trial.
willing to do that. Wait, let's get to
Well,
the last
I'm
one.
just-
Let's get to the last one.
No,
There's
that's-
that statement that he
I
doesn't support his
revoke
kids.
my concession. I see where you're going. I revoke my concession then. In that situation, no. That I would say that's out the presumption of innocence. If that's a separate offense, if the drugs upstairs are a separate offense that the government is choosing not to charge, then no, that cannot come in. The
Okay,
presumption of
not
innocence
pay-
would stand.
Failure
You
to
can
pay
only- let me
child
put it-
support.
let me
Failure to
put-
pay child
We're
support.
defining it in the negative. Let me define it in the affirmative, in the positive, if you will, positive law. You can only be sentenced for stuff you're found guilty of. That's it. That's it. Simple as that. The presumption of innocence must be overcome.
So criminal,
in order for you to
criminal,
be,
the particular.
Or that you admit to guilt in a plea.
or if you admit to it. Yeah, exactly. I mean, you either admit to it into a plea
Yeah.
or you're found guilty of it. That's
Okay,
it.
so
That's all you can
let's do
sentence of.
the failure to pay child support.
No way
Okay.
could that come in. That's Frank. I'd argue it couldn't come in now. That's irrelevant conduct. That would be irrelevant conduct.
Well,
it's not part of the common course scheme. Or plan.
Here's
He's been using the money that he's making from drug dealing
Yeah.
to pay for illegitimate stuff and not paying for his kids' welfare. Again, I think we would definitely think that's part of 3553A, history
Yeah.
and characteristics of the defendant. The point is,
I
and
would
this
argue
is-
that's irrelevant conduct.
we
That
can
doesn't come
belabor
under
it all you want,
111.3.
then you're saying the only thing he can be sentenced for is that which exactly he was convicted of.
Yes.
Then the question, then why do we need discretion for judges? What is the
Think-
judge
well,
thinking about?
but you know what?
because
Wait a
there's
minute.
sentencing ranges. Yeah,
But
because
we-
that's where
Why
the
is there a
discretion comes in.
range? There shouldn't be a range. If they're going to only be convicted for sentenced for what they're convicted of, what's the basis for a range? What judgment is the judge using? Because they're not supposed to consider anything other than conviction.
Well,
why shouldn't there just be
and-
fixed sentences for
Be-
each
because there
crime?
could be-
And that's
because there-
it.
There could be sentencing factors that are not elements of another crime that underlie that fact, such as the drug.
What
amount.
difference
So-
does that make? There's a
So
ton of
wait,
elements. that
let's
should
just,
all be-
let's just take a very easy case. Let's just take a very easy case. So you have a defendant pleads guilty to drug trafficking. And now the amount comes in. So the amount is not a factor. Forget about mandatory minimums for a second. So the amount of drugs, marijuana, is not a factor when it comes to whether or not he's guilty of the crime of drug distribution. It is a factor, though, and it's a traditional factor for purposes of sentencing. So now what the judge must decide is how much of that drug amount that the government is accusing the defendant of having, of distributing, how much of that is actually attributable to him under that offense of conviction. And kind
You
of
mean uncharged conduct
now.
You mean uncharged conduct. You mean uncharged conduct. You're just
No. I'm not saying uncharged conduct.
Uncharged conduct.
It's the part of the charged conduct. What has he been charged with?
He's only been charged with distributing drugs. He hasn't been charged with distributing a certain amount of drugs.
Because
so
you're saying
the entire loss table's fine too?
No, I'm not saying that at all. There is no.
It's the exact same thing.
No, it's not. It is not.
But if you're well, so
of course
first of all,
it's the same thing.
But wait a minute. You understand you're talking about two completely different things in this debate that you've conflated and intermingled, which is sentencing guidelines, which have these charts and these tables and increase for the amount of drugs and these things that we hate, and 3553, which basically just generally says a judge must consider the nature and circumstances of the offense and the history and character of the accused. And so those
I'm making the point that everything is uncharged conduct except for the exact things the jury finds guilt on. And so if you say no uncharged conduct at sentencing, you're basically saying we need fixed sentences attached to what the jury finds.
No, wait. I am saying no uncharged conduct can come in unless, using the government's language, because I agree with this, it directly underlies the elements of the offense. And so, yeah, we have to flesh that out. What does it mean to directly underlie the elements of the offense? And yeah, do I have a clear blueprint or a clear line? No, I don't. But that is a start right there. It has to directly underlie the offense. I'll give you a clear example of what wouldn't come in. My fraud example. So you defraud this group of investors or this bank of $1 million, and you defraud in a completely separate thing another bank of $1 million, and you're acquitted on, or you're never charged for that second bank. You're only charged and you're convicted of this first bank. That second bank, the conduct around that second bank will not come in. That would be uncharged conduct.
Okay, but how about if I admit I defrauded the bank of $1,000, and the government says, no, you defrauded them of $10 million. How does that get resolved?
But that's not going to be in the indictment.
Of course it's not going to be in the indictment. So isn't that
you're changing? Wait, go with my, no, you're changing the hypo. You got to go with my hypo. Different bank, different amount. You're talking about sentencing factors. So if you're
and that's the point. These are all sentencing factors. And the question fundamentally is, are there special sentencing factors, the ones the jury rejected, versus all the other ones? And you seem to have a vision of, uncharged is really separate stuff. But everything that brings down a defendant under our existing guidelines that you hate, quantity of the drugs, number of images, amount of loss, that's all uncharged too. But for some reason you seem fine with that, which I don't understand. If I have a presumption of innocence, and I say I'm not guilty of a $10 million fraud, I only admit to $1,000 fraud. How is that any less of a concern? In fact, that's going to come up far more.
Okay, here's the fundamental. I think the fundamental difference that we have, or maybe misunderstanding. When I talk about a presumption of innocence, I'm talking about a presumption of innocence as to a crime, not as to sentencing factors. You don't have.
What are sentencing factors?
I'm sorry?
What are sentencing factors other than uncharged conduct?
Sentencing factors. This was the whole thing about Apprendi and the whole line there. It's basically the difference between an element of an offense and what's not an element of the offense.
In other words, uncharged conduct.
Drug amount is not an element of the offense unless you're talking mandatory minimums.
Right. It's uncharged conduct.
Loss amount is not an element of the
It's uncharged conduct. That's my point.
It is not uncharged conduct. So basically
what you're saying, so here's what I understand you really say.
Yeah.
The things that Mark thinks are unfair That's
No.
off the table. But
Element
I have
of the
no
offense.
definition of that.
Element
I have
of the
no
offense.
definition of that other than what
Elements
I
of the
think
offense.
counts.
No,
So
uncharged conduct is other conduct that can be an element of a chargeable offense, an element of the offense.
yeah.
That's not,
So look
but
at-
there's lots of
That
stuff.
is uncharged, that's uncharged conduct. And nobody has
look-
ever said sentencing
And you
factors
say that can't be
constitute
used.
uncharged conduct.
You're saying uncharged conduct can't be used, right?
But we have a different definition of uncharged conduct.
Right. Your
I'm saying
definition
uncharged conduct
your
can't be
definition
used.
seems to be what you don't think is right, but that other people are supposed to understand. And the
No,
guy who
no,
says,
no,
I only
my
did,
sense of, no,
I
my
only
sense
did
of-
2 drug sales. I
Yeah.
only did 2 drug sales with half a kilo, but the government says I did 100 with 100 kilos. That
Well, if those
That's not
drugs, but
uncharged
you're
use.
talking about different offenses. If it's a different offense, it cannot.
it's all
come
one
in
drug
unless-
conspiracy, my friend. This is exactly what was going on in the Jones case that they dissented on. He said, I was only doing a handful of sales. The government said you were part of a vast conspiracy. He was convicted only of the individual sales, but ultimately, despite being acquitted, that's the difference. That's the difference.
He was acquitted of other offenses. That is not the difference. That's proving my point. This
No.
has to do with offense conduct, crimes, not sentencing factors. And
again,
that
okay, so
universal
let me
sentencing
ask you this.
factors-
Let me ask you this. I'll
that
put it in these terms.
universal
How does a
sentencing factors is
defendant,
determined
how
by
do you
the
explain,
elements of the
to a
offense.
defendant? How do you explain to a defendant who says, I've been charged with this big bank fraud,
Yes.
and it's true that I did not tell the bank what my true worth was, and I think that ended up costing the bank $10,000 that I didn't pay back right away.
Okay.
The government, though, says it ended up costing the bank $10 million, and they're going to say that's the actual loss of the bank, and the bank has a receipt that says this ended up really
Loss is
costing.
not an element of bank fraud or wire fraud.
So
Loss
you're,
is
but
not
you're,
an
you're,
element of the
but I
offense.
want to be clear. So you think it's perfectly fine for the government to come in, go to the judge and say, I know if it was a $10,000 loss, this would only be a 2-year range, but we have a statement from the bank that you should be convinced of by a preponderance of the evidence that this was really a $10 million loss.
Wait, Doug, we're talking two different things here. But here's what I would say in a situation like that. If the government is charging you with bank fraud and they want you to stipulate to an amount, don't stipulate. Plead open. If they won't agree to an agreement that of $10,000, they want 10, then plead open and let the court decide what the loss amount is.
But you think there's no, you see there's no problem at all with the court deciding that was a $10 million fraud.
If it's going to, well, as to that bank, as to what underlies the offense of conviction, did you steal $10 million or $10,000 from this bank? Yes, a judge can decide that. Where it's uncharged conduct is if the government starts pointing to other banks that you ripped off.
But they didn't
never
charge me with
that.
They didn't charge me with a $10 million fraud, and they're going to sentence me for a $10 million fraud, right?
Not necessarily. That's where you plead open and you fight it
And
out.
again, so you're perfectly comfortable.
Where does that $10
Again,
million come from?
First of all, I don't think he's perfect. I don't want to put words in your mouth. That is the system we're under right now, that they don't allege loss in the indictment.
Right.
So you admit to the elements of the underlying offense of fraud, and then the judge has to determine it. To say that anyone's perfectly fine with that, I don't think is accurate, because I don't like it, and I think it should be a higher burden of proof.
Let me try to use some terminology. My sense is what Mark's really saying is you shouldn't be sentenced on unrelated conduct.
No,
You don't have a problem with uncharged conduct.
No, let's make it concrete. We'll give you an example of a hypothetical case. The client is charged with taking a kickback in a construction project that he's working on, because he has this one guy who he always favors to get this project. And once he gets this guy on the project, this guy gives him a little love for thanks for that. And it's a kickback. And this company found out about it, and putting Simonelli aside for now, but said, had we ever known of this agreement, we would never have sanctioned this, and we would never have given that guy the money in the contract. Okay, fine. So he pleads guilty to that. And all of a sudden they say, by the way, these two have known each other for 10 years. And let's look at the job he did 5 years ago at another company. And let's look at the job he did 7 years ago at another company. They've been doing this for years.
Yeah.
And therefore the loss should be, that's what we call relevant conduct, because it's part of the same scheme or plan that's what they're saying. And therefore the loss is now $1 million instead of 50,000. And that's what we're real
right. It's that other conduct for those other schemes that cannot come in.
Why didn't you just charge him with that?
That's suppose they charge a conspiracy that covers that entire period.
Doug,
let me just ask. They charge a conspiracy that covers that entire range of years. And that's what they get a conviction on.
Well, they didn't do that, though. That's the point. They could have done that. Yeah, they should have done that. Right. And the underlying fear that we had is that they didn't do it because they could never prove that those things actually met all the elements of fraud, because simply taking a kickback is not necessarily illegal unless you have these other factors that go along with it. So what you have is the government saying, this seems shady to me. We don't really like it, but we can't prove it, so we're not charging it, but it's open season on you. When you get to sentencing, we're bringing all that in. And then the judge gets to say, oh yeah, he's been doing this for years. And then he gets a sentence that may be 5 or 10 times greater than he would have gotten if it was just this one incident that they were able to prove. And that's so fundamentally disturbing.
Right. But if he is charged with a conspiracy involving all that conduct and he's convicted,
that's a different story.
That's a different story. That's charged.
No, but here's the point. Here's the point. You're saying it's the same story, even if he's charged and acquitted, because you say there's no difference between acquitted conduct and uncharged conduct.
Yeah,
that's
correct. That's absolutely correct.
That's the key point. Yeah. Doug is rightly offended by the fact they don't even charge this guy because they don't think they have the goods, and then they try to shuffle it all into sentencing.
Right.
Now, I've been having a fun time highlighting to you the reality that defining uncharged conduct is really hard and creates all sorts of problems, because you actually aren't talking about uncharged conduct. You're talking about what you want to define as.
No. 100% disagree with that. No, that is not my position.
Well, then explain to me why drug quantity.
I just explained, and Doug did too. Doug Passage did too with that example. That if
because what you're really saying is, if you want to get him for that, what you're saying fundamentally,
if you want to get him for that, you got to charge him. If you want to get him for
but what I'm saying is, if you charge him and lose, you still get to get him for that. The very principle you're putting forward, that this is more offensive because it's uncharged. Fails to recognize the fact. No. I'll tell you when it's most offensive. It's most offensive when it's charged and acquitted, and you still get to punish them.
I can short circuit this because wait a minute, time out. Yeah. I agree with you, Professor Berman. I think it is more offensive because you've gone through a jury trial, and I agree with you about the sacrosanct of the jury, everything else. But that doesn't make it may make it more offensive, but it doesn't make the other thing.
I agree wholeheartedly. The terms of this debate is not whether.
But it doesn't matter how offensive or not it is.
And I also believe. Wait a minute now. I'm not missing your point. I get your point, but in terms of the level of offensiveness when a jury says not guilty or hung, I would submit to you that uncharged conduct is arguably more insidious, because the suggestion is they didn't even have enough evidence to get to a jury for the jury to make that determination.
So
you don't get the privilege of having that jury give that stamp, that stamp of that imprimatur of no, because they can't even get to the courthouse doors.
Just so you know that we all agree, and I'm playing up our differences. Of course, in certain settings, uncharged conduct is incredibly offensive. I'll give you the settings that come up the most. It's a couple of cases I've worked on in a variety of settings and lost in arguing due process principles here. They involve cases where one involved a police officer who pulls somebody over, the person disappears, and then later the police officer uses his credit cards as an ATM. Another involves, a couple where a woman goes missing. He ends up using all of her financial information. And then in both those cases, The defendant's convicted of fraud. The government comes in and says, we've got some pretty good theories that they killed that person, right? That person's missing. We can't find a body. They're completely gone. Nobody's objected to any of this. We think this fraud defendant actually killed somebody, but we don't have a body, so we're not going to charge murder. We're not going to win that. But we're just telling you, Judge, because, you know, we got to tell you all the facts about this person, and we sincerely believe in our hearts that they killed that guy and sentenced accordingly. And sure enough, a judge comes along and says, yeah, that kind of makes sense to me. Where is this person? I'm giving you now 30 years instead of 5 for this fraud. And two things to emphasize about this point, two things that go to the heart of the problem here that we're talking our way past. One problem, statutory ranges are too broad. They're especially too broad if we care about keeping punishment tethered to counts of conviction. Fraud shouldn't be a life sentence, even for lots of fraud, unless it's an aggravated fraud. This is a code reform problem, first and foremost. Second, I agree that in lots of cases, the application of a preponderance standard or having judges find uncharged conduct to radically increase a sentence is a violation of due process. But that's a different concern than the violation of the jury trial right that acquitted conduct creates, all of which is just in service to my point, which is these are all horrible as a product of a very broken sentencing system. But I would encourage and return to the idea that no matter how broken we think this sentencing system is, the fact that you want to allow judges to make some fact finding that you want to call marked sentencing factors is proof to me that you are prepared to defend a judicial role in aggravating punishment above and beyond that which is the basis for the conviction. I largely agree with that. And I think then there needs to be gradations here. One of those gradations is to distinguish what you call uncharged conduct from what I call acquitted conduct. Another gradation is from what you call bad uncharged conduct and what I would call what you think is good uncharged conduct, like loss amounts and drug amounts. Though I suspect you'd agree with me that those findings by judges shouldn't elevate sentences by decades. That the difference between the $1,000 bank fraud and the $10 million bank fraud ought not be a 30-year spread.
Sure. Look, you know, yes, we're talking about something else though. Now we're talking about a critique of sentencing guidelines overall and how they should function and what matters to a judge, what weight they should give, what the role of the commission is, and all this other stuff, and the role of a judge at sentencing,
and the role of a jury.
But that's way far afield than I think what our core debate is about. And our core debate is if the presumption of to me the core of the debate is if the presumption of innocence means anything, then you cannot distinguish acquitted conduct. And it might be a flavor. We might be discussing two different flavors of evil here, but it's evil nonetheless. Acquitted conduct and dismissed and uncharged conduct. If the presumption of innocence means anything, it doesn't distinguish between those three. Now, there might be certain, like I said, flavors of evil here, and it might matter. Some things might look uglier than others, but at the end of the day, if the presumption of innocence means anything, it means you are presumed innocent of any and all conduct, and you cannot be sentenced for conduct you're innocent of unless until you're proved guilty of it. And
again, I want to understand, but that doesn't apply, as it sounds like, to any requirement of proof of drug amounts, proof of loss amounts.
As long as it underlies the offense of conviction. We had, so here's where it would distinguish. If we had Blakelyized the guidelines, as Professor Bowman had argued for years ago, where every sentencing factor was considered an element of the offense, then absolutely. Then loss, drug amount, role in the offense.
Well, let's keep it simple. Let's keep it with drug amounts. Are you saying to me that government has an allegation? Government has an allegation that I'm involved in 2 kilograms of heroin that I believe triggers a 10-year mandatory minimum.
Well, that's an element of the offense. Yeah.
But they choose not to charge me with that. They just allow me to plead guilty without the applicable mandatory minimum. Does the judge get to consider the drug amounts there?
For purposes, well, you're setting me up here because for purposes of what? Yeah, for the mandatory minimum. Well, of
No,
course
for
not.
purposes of applying, the guideline range is still 0 to 20.
No, you've avoided the mandatory minimum, but now you're going to be in a guideline range that's life because they're going to get to put in all its drugs. We've glossed over a very central element here, and you raised it earlier, Professor Berman, but isn't the heart of this argument, because I think fundamentally, I probably am okay with judge determining sentencing facts that increase, but only if the standard of proof is beyond a reasonable doubt. That's really the issue here, because it takes so little for a judge to make these findings. And so Supreme Court, I know you're listening to this podcast. Here's the easy fix, man. Just say, if you want to enhance a sentence based on uncharged or relevant conduct, go ahead, do it with proof beyond a reasonable doubt. And you notice I omitted acquitted conduct from that, because if you make your standard proof beyond a reasonable doubt, there's already been a jury finding that proof beyond a reasonable doubt doesn't exist. So end of story, be done with it. And now what we have is essentially not necessarily jury trials, but sentencing trials, where real evidence, real proof, real cross-examination, real confrontation, all those rights that really don't exist because hearsay is admissible, and it's wild west at sentencing and so easy to prove. Then we have due process. Then we have real constitutional protections. Then it means something. That's what I would like to see, and I'd be okay with it, because I don't necessarily think having a jury come in and determine all this stuff is going to be the way that we want to go.
Doug,
but of course, just to finish, just to bring it back to what I'm saying, that's never going to happen because of the sickness. We're about speed, and no judge wants to turn a sentencing that probably would have lasted 15 or 20 minutes into a day or a week-long trial where we're arguing about sentencing facts. So I'm sad to say that's a dream that's probably never going to come true, but that's what I want to see happen.
The additional complication to your dream, though, is you would also have to get rid of Federal Rule of Evidence 11,001, which says that the rules of evidence don't apply at sentencing. You're going to have to bring those in too.
You wouldn't have to totally get rid of it, because I think still for mitigation, there's special constitutional protections that a defendant should have to bring a mitigation in, that a government should be held to a higher burden to bring aggravation.
Is different. Mitigation is different than aggravation. It's always been different. You've never had to prove mitigation by.
So, well, then what's wrong with doing away with hearsay if it means the government has to bring in real evidence that you can cross-examine and confront? Especially to drug conspiracy.
Trying to aggravate, I mean, we're getting really hypothetical here, but if we're Blakelyizing the sentencing guidelines, which means every sentencing fact, there's no more sentencing factors. Any factor, taking Scalia literally, any factor that can increase a sentence must be treated as an element of an offense. Then what the guidelines have done is create a bunch of different offenses, a bunch of gradations of fraud, drug trafficking, child pornography, etc. Now we've blown up the federal criminal code. But if that's the case, then you can't have beyond a reasonable doubt and not also have the rules of evidence. They go hand in hand. And every sentence is going to be a trial.
That's where I'll jump in and I'll say, and again, this is where these things, I think, benefit from disaggregation rather than aggregation. I think that's been a fundamental problem with the post-Apprendi world. We still have these buckets, it's the pre-Apprendi world too, of element which has all of these rights, requires a jury, requires the rules of evidence, requires all the cost, to get to Doug's point, that comes with jury trials. And so then we have both functionally and formally a disaffinity for saying anything's an element. But then also we say everything else gets the most lax procedure. And you all know as practitioners even better than I do, the procedures are even more lax than that. We don't have really sophisticated findings by a preponderance. We don't have full hearings in which evidence is put forward with or without the rules of evidence, right? It's all done on papers, pre-sentence reports, things that are just quick, let's go. And to me, that's fundamentally, and maybe this is at the core of why I'm so eager to distinguish between acquitted conduct and uncharged conduct and all sorts of other things. I think we would benefit from a heck of a lot more nuance in all of these concerns, treating due process rights separately from jury trial rights, separately from evidence rules, separately from mandatory minimums or concerns about severity. There are necessarily aggregating values that are in play. That is why I end up screaming about trying to make distinctions here, not because they're perfect distinctions, but because fundamentally it has been our tendency to lump things together that I think has thwarted our ability to do more refined work in this space. Though I think at the end of the day, that's not our fault, certainly not those on this conversation, but the fault of our criminal justice system always treating sentencing as a backwater, saying the rules of evidence obviously don't apply. All these due process things, again, the idea, this is what actually Justice Sotomayor used in her statement, the woman on the street. I know the woman on the street doesn't think any part of the criminal justice system functions exactly the same as the civil justice system, to the extent that the woman on the street knows that distinction. And yet sentencing is a civil proceeding, essentially. And even worse than a civil proceeding, right? Because you can't get a jury to make a preponderance finding even. And that is where I think we're all on the same page, that these are all problematic realities. And then it's a question of how can we best unpack it. I tend to be an incrementalist. I tend to think we'll have a better chance starting with getting rid of acquitted conduct. And then once we do that, we're in a position to move on to the next stuff, especially with, and again, this is where, for me, this conversation's been so valuable. You're not saying all what I would call uncharged conduct is off the table. It's all conduct that's kind of separate. And of course, here's another point, which is itself useful. Maybe the answer here is not to advise the commission to rework its acquitted conduct rules. Maybe the answer here is to advise the commission to rework its relevant conduct rules.
Well,
because
that's fundamentally always promised to do. That's something, and you're exactly right.
That's what
6A 1.3, this whole preponderance of the evidence crap and the cornerstone behind the guidelines, the commission always promised they would take a hard look and look at those two cornerstones of the guidelines, and they never have. And that's really what they should do. Forget about all this acquitted conduct stuff, because they can't do anything about it anyway, according to Alito, and I think he's right. But they can do something about relevant conduct and 6A 1.3 about this preponderance of the evidence. It's time that they take a look at that. And some of these sentencing factors, like loss and drug amount, should be have a higher evidentiary standard at the very least. Like
let me return us where we started, and this is, I think, really incredibly useful. Among the reasons I'm inclined to move toward the commission as the remedy here is because as a policymaking body, they can draw distinctions that's awfully hard for a constitutional court to do, right? So they can say something like relevant conduct or uncharged conduct or acquitted conduct, or whatever the label we might have for a particular kind of conduct, can never enhance the sentence more than 2 levels under the offense charge or whatever else, right? That's, to me, where they can bring nuance in a kind of rulemaking way that you're not going to get a Supreme Court to say, well, you can consider acquitted conduct if it's only 6 months or a year, but you can't consider it if it's more than 2 years. That doesn't work for a court quite as well, especially the Supreme Court, as it can work for a commission. Now, we may not like the commission's compromises, but I think until the commission starts doing that work, we can't even understand what the impact will be. And that's why I hope they'll do something on this front and others ASAP.
Well,
they got a lot on their plate. So I'm not holding my breath.
Perfect place to put a pin in that. And so I will stress, contact the commission, tell them they need to deal with this. It sounds like in the "you get murdered first" debate, you say it's the commission's deal. By the way, I'm waffling. I feel like Flavors of Evil may be a good title for this too. I've got Homer Simpson in my head. Flavors of Evil. But it was a super valuable conversation. It was a fun-spirited debate. I'm so grateful for the two of you that you both came and ripped each other to pieces, but walked out of the ring with both of you with your head held high. I'm not going to declare a winner to this debate. I'm going to just say it's a tie. And but definitely reach out to the commission. Definitely preserve these issues in your case, because they're alive and well. And definitely check out Berman's blog and subscribe to it if you haven't, because it's filled with great stuff. Definitely visit sentencingstats.com or reach out to Mark Allenbaugh if you need some help in your case. And check out definitely in the show notes a link to him and Alan Ellis's Law 360 article. And definitely the two of you come back and fight with each other like cats and dogs soon on Set for Sentencing. Thank you very, very much. We'll see you soon. That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.